And welcome to my morning, Sunday morning coffee with Dr. Childress here. In today's uh, coffee episode, I'm going to be discussing forensic psychology. I'm going to be starting to take my deeper dive into the family court issues involved. And there are specific people who have created this field of forensic custody evaluations that is absolutely awful and that has driven the standards of practice to the absolute lowest level, below lowest level. For an example, parents should never have to explain to the doctor what the pathology is. Patients should not have to explain to the doctor. The doctor should be explaining the pathology to the patients. However, you, parents, have to explain the pathology to the forensic psychologists who you've been given. And that is fabulously low professional standards of practice in forensic custody evaluations in forensic psychology. And there are people who created that model. It's not just something that dropped from the ether. There are people who create it and perpetuate it, specific people. In addition, there are specific people in positions of power who are disabling the mental health system response to the pathology in the family courts. And I don't want to get into any trouble. I've gotten into enough trouble. Forensic psychology hates me enough at this point, and they control the licensing boards. It's very dangerous for me to be over here right now. But it needs to happen. There needs to be accountability for the failed experiment of forensic psychology. And we need to get outside and independent review and revision, and clinical psychology needs to come back. But first, we need to understand what's happening over here, and how the field has been driven to the absolute lowest quality of professional standards of practice. So that's what I'm going to be talking about today. Beginning to talk about is the forensic custody evaluators, and what's going on in the family courts. So I want to start with the AFCC, the Association of Family and Conciliation Courts. That's the professional organization of forensic psychologists and family law attorneys. And so this is the professional organization that's responsible for forensic psychology and the forensic custody evaluations that you families are getting in the family courts that solve nothing, that are unethical for a variety of reasons, that are harmful to children, and that are just the worst quality of professional practice. And here, the AFCC puts out their model standards of practice for child custody evaluations. Now, I would say by doing that, they assume liability for the practice of custody evaluations. And that's where class action lawsuits or anything, if you want to put them on your class action lawsuit, this would be the document I would reference relative to that. But I'm not an attorney. I'm just a psychologist here. But the particular standard that is, there's many of them, but the particular one that's I find particularly egregious, is standard 4.6, presentation of findings and opinions. And it's 4.6C that's really a problem. And they say child custody evaluators shall strive, these are aspirational goals, strive to be accurate, objective, fair, and independent. Well, first off, they're not accurate because they're misdiagnosing the pathology. It's a shared persecutory delusion and factitious attachment pathology being imposed on the child. They are not accurately identifying that. They are just, I don't know what they're doing with it, but they're not accurate. They are not objective. There's no such thing as objectivity. It is called countertransference. We all bring our own biases and cultural values and everything to anything. So the idea that they're striving for objectivity is a thought disorder to begin with. What we do in clinical psychology is we don't strive to be objective. We limit the subjectivity by using standardized approaches, like applying the established scientific and professional knowledge as a basis for our judgments. We just don't make up opinions and make up stuff like they do in forensic custody evaluations. Now, I review forensic custody evaluations. That's kind of my job, is second opinion, and I get to read them all. They are not in any way objective. They are massively subjective. So they're failed. Fair, yeah, you're in the court system, but we should always be fair. But the last one, independent, that's superfluous. Psychologists are always independent. What do you mean we're subjective? No, we are always independent. We're doctors. We diagnose and treat pathology. And there's just a thought disorder that runs through all of this, and a straw man argument about clinical psychology. And they're strongly encouraged to utilize peer-reviewed published research. Well, that would be Bowlby, Mnuchin, Beck, Vander Kolk, Tronick, the established knowledge. Do they ever use it? No, they don't. They don't use any peer-reviewed published research. They have a lot of opinion pieces, but no research to back up anything that they're talking about. But here's the subsection that's particularly problematic, which is evaluators recognize that the use of diagnostic labels. Now, let's be clear on this. Diagnostic labels means the same thing as diagnosis. So the diagnostic label of schizophrenia is the diagnosis of schizophrenia. And so they use this diagnostic label issue to kind of fudge. They're saying evaluators recognize that the use of diagnoses can divert attention. So diagnosis means the same thing as identify. We must first diagnose what the pathology is before we know how to treat it. We must first identify what the problem is before we know how to fix it. So diagnosis is identify, pathology is problem. So they're saying, evaluators recognize that identifying the problem will divert attention away from the focus of the evaluation. That gives a clear, they are diverting attention away from the pathology of the narcissistic borderline parent. If we diagnose it, if we identify it. So for their mindset is their role is not to identify the problem in the family, because that diverts attention away from what they see themselves as doing, from the focus of the evaluation, namely the functional abilities of the litigants whose disputes are before the court. That's an interesting interpretation. I don't think that's the role of doctors. Personally, doctors diagnose and treat pathology. We identify the problem and we fix it. And so if you come to a clinical psychologist as a court or as a family, my role as a clinical psychologist is to tell you what the problem is and tell you how to fix it. Somehow the forensic custody evaluators don't see that as a role. They see themselves as getting into what the court is considering and how to apply this to the court's consider. That's the court's consideration. How the court decides to apply its laws or statutes or the issues before the court is for the court to decide. The role of the psychologist is to diagnose and treat pathology using established diagnostic labels because they are clear. They have definitions to them. And the cross-examination for this is just devastating, because you just ask, would you tell the court if there was a diagnostic label of schizophrenia for one of the parents? Well, yeah, I'd tell the court if one of the parents had schizophrenia. But would you tell them if the child had a diagnostic label of child abuse, child physical abuse, or child psychological? Would you diagnose that and use that diagnostic label of child abuse and tell the court? 4 diagnoses of child abuse in the DSM-5. Those are diagnostic labels: child, physical abuse, child sexual abuse, child neglect, and child psychological abuse. Those are diagnostic labels. Would you tell the court if there was child abuse? Well, yes. So then sometimes you tell the court the diagnosis, and sometimes you withhold the diagnosis from the court. I have a serious, serious problem with psychologists withholding information from the court, especially diagnostic information identifying what the problem is, and the psychologist is going to withhold that information from the court for whatever reason the psychologist thinks. That's inappropriate. As a doctor, you come to me, I'm going to diagnose the pathology, and then I'm going to tell the court fully and completely what that diagnosis is. The whole truth and nothing but the truth. I'm going to tell the court the child, has a shared persecutory delusion, and because it's being induced by a pathological parent. Now, where this came from, their concerns back in the 80s and 90s, is back in the 80s and 90s. We were just beginning to get a lot of these custody situations because of the divorce increase that happened in the, starting around the 70s. So in the 70s and 80s, there started to be a lot more divorces that weren't present in the 1940s and 50s. And so as the divorces happened, the court was faced with these custody issues. And as the psychologists came in to opine on the custody, they began to talk about the personality disorders that are involved. This is the pathology in the family courts is a narcissistic, borderline, dark personality parent who's producing pathology in the child for secondary gain. And so the psychologist came in and said, wow, we got a narcissistic or borderline parent here. And then the other side would get their allegations, or their psychologist to say, no, that parent's narcissistic or borderline. And so you get these dueling psychologists and dueling sides, each accusing the other parent of being narcissistic or borderline. And everybody got fed up with that and said, this is about the child. This isn't about, labels and use it. And so that's the diagnostic labels they're worried about, narcissistic and borderline. And so they don't want to use those. Instead, they want to talk about the functional abilities. Unfortunately, that got them into a bad path because they started to, not use any diagnostic procedures or process or thinking or anything. So their diagnostic labels supposedly divert attention, identifying what the problem is, diverts attention away from the focus of the evaluation, the functional abilities of the litigants whose disputes are before the court, and that such labels are often more prejudicial than probative. That's not the call of a psychologist. Okay, that's something you can argue in the legal setting, whether the information from the psychologist, the diagnosis, is prejudicial or probative. But it's not the psychologist's call to say that this diagnostic label of child abuse by the pathological allied parent would be prejudicial to that parent's ability to get the child in custody. And so I'm going to withhold that because the diagnosis of a shared delusional disorder, the diagnosis of a delusional thought disorder, is prejudicial to that parent. Well, it may be prejudicial to the diagnosis will be prejudicial to the pathological parent. However, it is probative to the other parent because they're trying to prove that that parent's pathology is creating the child's pathology. So it's probative to one, it's prejudicial to the other, but it's not the psychologist's call to make. The psychologist, the doctor, should diagnose and treat pathology. That's what we do. And so if the court sends somebody into us and says, what's the problem? We should identify the problem using established knowledge and using established diagnostic labels that are defined and that have meaning and that have associations in the literature and a whole bunch of stuff. Now, maybe we can avoid the narcissistic and borderline and dark personality labels relative to the court, but I think we need to inform the court that's where it's coming from. What we're worried about is the shared persecutory delusion that results with that. That's the functional abilities of the litigant. Do they have a persecutory delusion as a result of their personality disorder pathology? But we should be educating the court about the whole scope of this That one parent, the targeted parent, might be abusive. That's possible. Or the allied parent might be abusive, and that would be the shared persecutory delusion from a narcissistic borderline dark personality and a factitious attachment pathology imposed on the child for secondary gain. And we should be educating the court about that. Once the court understands that, we can stop using these labels because everybody kind of knows. We do need the diagnosis of child psychological abuse. We need the mental health people to make that diagnosis. We need an accurate diagnosis and one that the court can rely on. So we get second opinion in there. We use standard criteria, mental status exam. We can do that. But it's not the forensic psychologist's role, in my opinion. It's not the role of a doctor to decide whether the information from the psychologist, the diagnostic information, is prejudicial or probative, because it's going to be prejudicial to the pathological parent. It'll be probative for the normal range parent. Those are considerations for the court to look at all the issues before the court. When the psychologists get out of their role and stop being doctors and stop diagnosing pathology, that forces the court to then become the diagnosis of the pathology. And they're not trained, they're legal professionals, not psychological professionals. So the psychologists need to get back in their role of being doctors so that the court can go back to its role of deciding on the custody based on all the information that it has before it. And for these reasons, evaluators shall give careful consideration. They're not instructing them not to diagnose pathology. They're just saying, withhold that information from the court. Again, I have serious problems with doctors or psychologists withholding information from the court based on their own decision. And they're not only withholding it from the court, they're withholding it from the attorneys for both litigants. So if there's a diagnostic label that's appropriate, like child psychological abuse or persecutory delusion, they are withholding that information from the attorneys and from the court so that nobody knows. That's wrong. That's fundamentally wrong to do. That's overstepping the role of the psychologist in the situation and putting your finger on the scale of justice in favor of the pathological parent. The only outcome of withholding the diagnosis of a shared delusional disorder or factitious disorder or child psychological abuse, the only beneficiary of that is the pathological parent. The normal range parent wants that information in the court. So they are biasing from the start. They are biasing their evaluations in favor of covering up the pathology of the narcissistic borderline dark personality, the child abuse pathology. They are covering that up from the family courts. And so that's just this whole standard 4.6C of these model standards is extraordinarily problematic. And this is the one that I would link them into their participation in the nightmare of the family courts. Once they stop diagnosing pathology, once they stop being doctors, once they put their finger on the scale into the advantage of one of the litigants, the pathological litigants, things got way haywire. So in evaluating a litigant where there are significant deficiencies noted, evaluators shall specify the manner in which the noted deficiencies bear upon the issues before the court. Again, no, that's the court's decision. The diagnosis bears upon the issues before the court is the court's decision. What the court needs from clinical psychology is to identify what the problem is. If it's child abuse, diagnose the child abuse and tell the court which parent is abusing the child. When there is severe attachment pathology, a child rejecting a parent, the only cause of that is child abuse by one parent or the other. Lesser forms of problematic parenting don't produce a child rejecting a parent. They produce what's called an insecure attachment, more strongly motivates the child to bond to the parent. If we have a child rejecting a parent, that's child abuse by one parent or the other. Either the targeted parent is abusing the child, let's identify what the abuse is and put it on a treatment plan and fix it, or the The allied parent is psychologically abusing the child, creating a shared persecutory delusion and factitious attachment pathology for secondary gain to that parent. So let's do a differential diagnosis on that. Tell the court's going to need to rely on it. It's going to be adversarial system. It's going to be a disputed diagnosis. So let's get a second opinion right up front. Third opinion if we need it. But let's do whatever we need to do to bring the fighting to the close to get an accurate diagnosis so we can get an effective treatment plan. So that is right there. That standard is the core of the problem within forensic psychology. Now let's take a look at the evaluation, outside independent review of forensic custody evaluations, New York Blue Ribbon Commission. Apparently they had 20 members to that commission that looked at the practice of forensic custody evaluations in the courts. This is what they found. Ultimately, the commission members agree that the New York judges order forensic evaluations too frequently and often place undue reliance upon them. Judges order forensic evaluations to provide relevant information regarding the best interests of the child or children, and some go far beyond an assessment of whether either party has a mental health condition that has affected their parental behavior. So that last little piece there is what the court wants. It wants to know if either party has a mental condition that is affecting their parental behavior. Diagnosis. And so that would be the shared persecutory delusion. That's exactly what is being asked for by the court is, does a parent have a shared persecutory delusion? Narcissistic borderline dark personality is collapsing into delusional thought disorders that has affected their parental behavior, creating a factitious pathology imposed in the child. So clinical psychology needs to return, and we need to be providing the court with an accurate diagnosis of what the pathology is. In their analysis, evaluators may rely on principles and methodologies of dubious validity. That's your parental alienation. I would add resist, refuse dynamic. Dubious validity, absolutely. That is an absolutely 100% accurate statement. They rely on principles and methodologies of dubious validity. Maybe that's even generous. In some custody cases, because of a lack of evidence or an inability of parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny and are often accepted by the court with potentially disastrous consequences for the parents and children. So these defective reports get no meaningful scrutiny, and they're accepted. If they're accepted by the court, they can lead to disastrous consequences. These are harmful to children. These are harmful to their parents, and they're just bad. They're defective. Now, my role right now as a consultant in the family courts, I am that meaningful scrutiny. I'm a clinical psychologist. I apply the established knowledge of clinical psychology to the information they report. I go through them line by line. I am that meaningful scrutiny. I read their reports. I know how bad they are. And I am in complete agreement with the New York Blue Ribbon Commission. The forensic custody evaluations are extraordinarily bad professional practice and professional things, and the practice needs to be discontinued. By an 11-9 margin, the majority of commission members favor elimination of forensic custody evaluations entirely. I am in full agreement with that. They need to be stopped, and outside independent review said stop them because arguing that these reports are biased and harmful to children and lack scientific and legal value. Again, I read these reports. I am in full and complete agreement with the New York Blue Ribbon Commission. They are harmful to children and they lack scientific and legal value. At worst, evaluations can be dangerous. Yes, particularly in situations of domestic violence or child abuse. So we've got harmful to children, dangerous, lack scientific or legal values. Who created these monstrosities? These just didn't arise from somewhere, and they've been going on for decades. Who's creating this and who's doing this? These are psychologists who are conducting these harmful, dangerous evaluations that lack scientific or legal value. Somebody is doing these. And look at your name on your custody evaluation. That's the person who is practicing at this extraordinarily low level. These members reached the conclusion that the practice is beyond reform and that no amount of training for courts, forensic evaluators, and or other court personnel will successfully fix the bias, inequality, and conflict of interest issues that exist within the system. Beyond reform. So people talk about judicial education. No, there's going to the practice of forensic custody evaluations is just fatally flawed. Now, people develop this, specific people develop this approach that is fatally flawed, that's beyond reform, and they continue to practice it and they don't change it, they don't improve it, they don't do anything. There are people who are doing this, psychologists who are doing this. And this is not my opinion, this is outside independent review. So, the American Psychological Association Ethics Code. The forensic psychologists are in violation of multiple standards of the APA Ethics Code. When I do my line by line reviews of their custody evaluations, I routinely identify the three violations: a violation to standard 2.04, violations, which is bases for scientific and professional judgments, 2.01, boundaries of competence, and 9.01, bases for assessment. They don't know the established knowledge, therefore they don't apply the established knowledge, therefore their opinions as contained in their reports and recommendations are not based on information and techniques sufficient to substantiate their findings. And they're just made up stuff. Their personal opinions is all they are. 6 to 9 months, $20,000 to $40,000 to get a personal opinion from somebody. And when the pathology is possible, child abuse, a 6 to 9 month evaluation is negligent. We need to get a return on that diagnosis for possible child abuse quickly as we possibly can, because one parent or the other is abusing the child. We need to know that quickly, not 6 to 9 months, and then you don't even provide a diagnosis at the end. So we still need another assessment to get a diagnosis because a forensic psychologist didn't diagnose it. So here's 2.01, boundaries of competence. Psychologists provide services, teach, and conduct research with populations and in areas only within the boundaries of their competence based on their education, training, supervised experience, consultation, study, or professional experience. So it's education, training, or experience. Notice consultation, though, is in there. Okay, so I am competent in all this stuff. So one way of addressing the boundaries of competence issue is to consult with somebody who is competent, but they don't care. They just do not care about competence issues. They are lazy, ignorant, unethical, incompetent, and in violation of their duty to protect obligations. So it's malpractice. So the competence issues that are of concern is in the diagnostic assessment of delusional thought disorders. I can pretty much guarantee you that all forensic custody evaluators are in violation of this standard relative to the diagnostic assessment of delusional thought disorders, because the only people who know how to assess and diagnose delusional thought disorders are over in schizophrenia. That's where I got my training, 12 years working in schizophrenia. So I know they don't have that background in schizophrenia, so they're not competent in the diagnostic assessment of delusional thought disorder. I never even see them discussing that issue when it's directly relevant. I'll cite to a Milan quote about narcissistic collapsing into delusional thought disorders. Borderline means borderline between neurotic and psychotic. I mean, that we know they collapse into psychotic persecutory delusions, those personality types, and yet they don't even know how to anything about it. They're not competent in the diagnostic assessment of attachment pathology. I know that because the only way you get that is early childhood mental health. That's the attachment system. Once you leave early childhood, you don't really see severe attachment pathology. It doesn't suddenly develop, but it does in the family courts, which means to me it's a false attachment pathology, because if you don't see attachment pathology suddenly develop. If you have it, you're going to see it out of early childhood because you have a parent who's creating attachment pathology. You know, is insecure, disorganized, insecure, ambivalent, or insecure, avoidant, and you're going to see that attachment going through the childhood. But if it shows up suddenly in childhood, like around a divorce, that's a false attachment pathology. But they don't know any of that. They don't know it's a primary motivational system of the brain that's goal corrected. It never rejects a parent, but they don't know any of that. And the diagnostic assessment of family systems pathology, cross-generational coalition, emotional cutoff, inverted hierarchy, enmeshment, all the family systems pathology. I never see that discussed by them or applied. There's a wonderful Mnuchin diagram that shows exactly the pathology. 40 years, have they ever informed the court about the Mnuchin diagram and cross-generational coalitions? No. So they're incompetent. They're in violation of standard 2.01 on those three issues, others as well. They've never treated child abuse. They've stayed a very limited domain of working in the family courts. And you'll find this boundaries of competence on their vitas. And so and when you look at these custody evaluation vitas, typically they graduate and they go into forensic psychology. And that's the only place they have ever been, is in the family courts. So they don't know complex trauma and child abuse. They don't know delusional thought disorders. They don't know oppositional defiant disorder in the schools or anything. They just know this limited domain of doing their custody evaluations that they've created. So that's one. Then the other ethical violation that's prominent for them is standard 2.04, bases for scientific and professional judgments. Psychologists' work is based on the established scientific and professional knowledge of the discipline. That's attachment, Bowlby and others, family systems, Mnuchin and others, personality disorders, Beck and others, complex trauma, Van der Kolk and others, child development, Tronick and others, and the DSM-5 diagnostic system. That is the established scientific and professional knowledge of the discipline. Do they apply that? No, they do not. And I have a little checklist I go through line by line, and at the end I check off my checklist, and none of those domains of knowledge were applied in violation of 2.04. The reason they don't apply them is because they don't know them. That's the violation of 2.01. They don't know, they don't apply. That's a violation of 2.03, maintaining competence, but they were never competent to begin with. And because of they don't know the knowledge, 2.01, don't apply the knowledge, 2.04, they are then in violation of 9.01, bases for assessment, in that their opinions, as contained in their reports and recommendations, are not based on information, 2.04, or techniques, mental status exam of thought and perception, sufficient to substantiate their findings. So I have 3 ethical violations for every single forensic psychologist out there. So I also have ethical standards governing me in this situation. 1.04, these are mandatory. Ethical guidelines or ethical standards of the APA are mandatory for psychologists. So they were required to know the knowledge and apply the knowledge. This is required of me. When psychologists believe that there may have been an ethical violation by another psychologist, yes, I do. I believe all the forensic psychologists are in violation 2.01, 2.04, and 9.01. They attempt to resolve the issue by bringing it to the attention of that individual if an informal resolution appears appropriate and the intervention does not violate confidentiality rights. So my ethical concerns, there may be an ethical violation to 2.01, there may be an ethical violation to 2.04, which would lead then to an ethical violation to 9.01. So now I have to bring that to the attention of every single forensic psychologist. That's impractical. for this situation. But this, what I'm doing here, is sort of my informal notification. I'm putting it out there to people, to the forensic psychologists, that you're in violation of these ethical standards. And this is from my 2017 presentation to the National Convention of the AFCC. Dorsey Pruder and I went to the National Convention of the AFCC and presented to them. I presented on my piece, and then she and I presented on the High Road Workshop protocol, what it is and how it achieves its success. Now, so this is from that slides. Pull them up. Professional competence. You can see down there, Childress and Pruder, 2017. I kind of like the idea that Pruder's on these slides, bashing them for competence, since she's taken so much heat for not having a doctoral degree. I had 4 slides, and this is the reason I went to the AFCC, is to present them with these 4 slides pursuant to my obligations under Standard 1.04. I am notifying them that I am concerned that they are in violation of boundaries of competence, because they don't know the attachment system, they don't know personality disorders, they don't know family systems, they don't know complex trauma. The delusional thought disorders is contained within the complex trauma and the personality disorder competence. That's where the delusional thought disorder arises from. Factitious attachment pathology is the first one. Family systems, cross-generational coalition, emotional cutoff, enmeshment. And so I told them, pursuant to my obligations under 1.04, I fulfilled them and I documented that. I discharged my obligations under 1.04. Did they do anything about it? It's been 5 years, 2017. Have they done anything to improve the level of their competence? No, they have not. The AFCC has not taken any steps to improve training, or the individual psychologists have not taken any steps because they're lazy. They're just lazy. I also have additional ethical obligations regarding ethical violations. That this is so important that the psychologists self-monitor within the profession is so important that the APA gave it 2 complete standards. It didn't put it as 2 parts of one standard. It gave it 2 separate standards. So first, don't rush to the licensing boards. See if you can handle it informally. So I did. I went to the AFCC and I told them, okay, but now 1.05, if an apparent ethical violation has substantially harmed or is likely to substantially harm, yes, that criteria is met. This is like a legal statute. Each phrase, each criteria needs to be met. So the first one, that the ethical violation has substantially harmed, yes, it has, or is likely to substantially harm, yes, it will, a person or organization, the children and families in the family court, and is not appropriate for informal resolution. It's not, because it's system wide, and so I can't run around and tell each one under standard 1.04, or is not resolved properly in that fashion. So I went to the APA, they haven't done anything, it's not been properly resolved by my informing them. Then I am required to take further action appropriate to the situation. Psychologists take. So what would be further action appropriate to the situation? I can't go to the licensing boards because the forensic psychologists control the licensing boards. That's the problem. They have disabled the licensing board oversight of forensic psychologists, because the forensic psychologists who are unethical and incompetent and are reviewing other forensic psychologists. That's the problem, is the licensing boards are corrupted by the forensic psychologists. And I put my license on the line and took a dink on my license from Oregon to expose that. And the Oregon sanctions are total nonsense. I was consulting with Dorsey Pruder in a business organization in California about data profiles that she generates through her research. I'm not conducting an evaluation of somebody in Oregon, but the Oregon Licensing Board, the forensic psychologists on the Oregon Licensing Board, massaged the law that exempted me from their jurisdiction so that they could specifically sanction me, because my report resulted in a board complaint against the involved psychologist in Oregon. That was the only use of my report, is it was used to support an ethics complaint to the Board of Psychology in Oregon. So they expand their law and sanction me directly to retaliate against me. That's why no clinical psychologist will work here. We face retaliation from the forensic psychologists on the licensing board. How do you think things got so bad over here? Who's supposed to maintain professional competence? Who's supposed to enforce the APA ethics code? The licensing boards. And if it's not happening, if we have bottom of the barrel practice, that's a failure of the licensing boards. Why? That needs to outside and independent review, likely from the legislatures. So and then it gives me suggestions. So I might take it to national committees, professional ethics, state licensing boards, or appropriate institutional authorities. So in 2018, I posted a petition to the APA, got 20,000 parents, signed the petition to the APA. I hand delivered it with two other parent advocates, Wendy Perry and Rod McCall. We went back into the corporate offices of Washington, D.C., and hand delivered a petition signed by 20,000 parents that described the ethical violations in the family courts. And the moment I did, I put up this website, the APA Ethical Violations and Complicity with Child Abuse, and put a counter on it. So we're now up to 1,943 days without a response from the APA. They just simply ignored what's going on. They are participating in the cover-up. Now, well, I'll address this in a second. Who did they give that to? Because whoever they gave that to is the person or people who are disabling the mental health response to what's happening in the family courts, because the APA knows there's ethical violations over here, or shouldn't reasonably know. And so between the two of them, between the AFCC presentation and the petition to the APA, I've documented the cover-up by the AFCC and by the APA, that they are simply not addressing it. And then the legislatures can address the cover-up over in the licensing boards. And it's not the field of psychology, it's the infection of the forensic psychologists into these systems that then disables the systems. And so that's the key piece that everybody needs to realize. These forensic psychologists are awful, awful, awful. And they are in positions of power and positions, and they are disabling the mental health system response. We have to cleanse professional psychology of these people. Okay. So, and clinical psychology needs to return. So the question is, where are the licensing boards enforcing ethical standards of practice? They are nowhere to be seen. And so if you pull that string, you will find where the problem is. That why aren't we getting proper oversight of the AP ethics code? Because the moment they do, we're going to be sanctioning all sorts of license of these forensic psychologists. So let's start with who's responsible. I'm going to put Dr. Simon and Dr. Stahl right up front and center for being responsible for all of this. So Stahl and Simon, 2013, their forensic psychology consultation. This is their book, Forensic Psychology Consultation in Child Custody Litigation, a handbook for work product review, case preparation, and expert testimony, published by the American Bar Association. This is their model. This is the one that they propose being used. So the fact that it's a complete failure, it's an experiment. They developed this experimental new approach of these forensic custody evaluations. It sits with them. And then in 2020, they do their second edition of this, switched authors, Simon and Stahl. So I would start by holding them accountable for their failed experiment in service delivery, and for all the unethical practices that are involved in it, and for their failure and duty to protect. Let's start with them. So just reminding you that the New York Blue Ribbon Commission found that these evaluations are harmful to children and lack scientific or legal value. So what Simon and Stahl are proposing is harmful to children and lacks scientific and legal value when outside and independent review is made of what their proposals are. So let's take a look at some of the statements from Simon and Stahl from their two books. In 2013, Stahl and Simon say, as a formal and organized field, forensic psychology has entered its adolescence, but it's far from mature. They are experimenting on you. They don't know what they're doing. They're making it up. That needs to stop. In 2013, it needs to stop. What do you mean that you're in your adolescence, but you're far from mature when the child is depending on this getting an accurate diagnosis? The court's trying to make this huge decision, and you're still kind of coming up with how to do things. No, get away. Get the clinical psychologist back. We'll diagnose and treat the pathology. We'll tell the court what the problem is, and then we'll fix it. So we need to get rid of forensic psychology and get clinical psychologists come back, but we won't come if it's too dangerous for Dr. Childress to be in the family courts saying ethical standards. If I get sanctioned by a licensing board for jurisdictional things, that is too dangerous. The forensic psychologists on the licensing boards will, for a fact, retaliate against any clinical psychologist who's over here, simply because we're not forensic psychologists. And we know that. The clinical psychologists know that. That's why they don't come to the family courts. It's too dangerous to our license. We need to cleanse professional psychology and the family court system of these awful, awful, awful psychologists. Cite to the New York Blue Ribbon Commission. In 2020, Simon and Stahl say, as a formal and organized field, forensic psychology has entered its adolescence and is far from mature. 7 years later, they haven't made a bit of change. They're still in their adolescence and far from mature. What do we need? Another 30 years for them to figure out what they're doing? While we watch family after family, child after child's life destroyed by their ignorant and incompetent malpractice? That's outstanding. If that's your lawsuits, I mean, holy cow. You get them on the stand and you ask them to explain how they make no progress at all, and they still don't know what they're doing. 2013, Stahl and Simon say these facts serves to illustrate the reality that as an organized field, as an organized systematic approach to behavioral science, forensic psychologist remains in its formative years. They still don't know what they're doing. 2013, they have no idea what they're doing. They're still kind of forming it up. 2020, this illustrates the reality that as an organized field and as an organized systematic approach to behavioral science, forensic psychology remains in its formative years. Get rid of them. They need to go. They are destroying the lives of children and destroying Stahl and Simon and Stahl have a failed model of service delivery. Done. Whatever they're doing, whatever they think they're doing, done. They've had their 40 years of failure, and they have resulted. Their model has resulted with what's happening in the family courts. There are names associated with this failure. Just to point out, Simon and Stahl, not as say in 2020, they said the same thing in 2013 too. Not until 1994 did the American Psychological Association recognize the importance of formalizing guidelines for child custody evaluations by publishing its first set of child custody evaluation guidelines. So again, it's an experiment. They're coming up with this new approach to service delivery. 1994, they say, hey, maybe we should get some guidelines for this new approach that we're using with parents that is just made up. We're just making this stuff up. It's not based on anything out of clinical psychology or healthcare. It's not based on diagnosis or treatment or any established healthcare principles. It's just something they're just making up because they're authorized to from some reason. And so in 1994, but if you 2004, 2014, 2024, that's 30 years. 30 years. And as a formal and organized field, forensic psychology has entered its adolescence, but is far from mature. In 30 years, they're still in their adolescence, but are far from mature. What do they want? Another 100 years to come up with their model? And done. done, done. Blue Ribbon Commission, done. They're harmful to children. They're dangerous. They lack scientific and legal value. What Simon and Stahl are proposing is dangerous and lacks scientific and legal value. That's the fact. So my question is regarding delusions. Are Dr. Simon and Dr. Stahl competent in the diagnostic assessment of delusional thought disorders based on their education, training, and experience? Or are they practicing beyond the boundaries of their competence in violation of standard 2.01 of the AP Ethics Code when assessing and diagnosing delusional thought disorders? You look at their vita, and I will at some point, we'll look at their vita and see are they competent based on their education, training, and experience in the diagnostic assessment of delusional thought disorders. I can pretty much guarantee no, they're not, because that knowledge only comes out of schizophrenia. They don't have any background in that. They're not consulting on that. So they're in trouble. I think they're in violation. Standard 1.04. Are Dr. Simon and Dr. Stahl competent in diagnostic assessment of attachment pathology based on their education, training, and experience, or are they in violation of 2.01 of the AP Ethics Code? So that comes out of early childhood and stuff. And this is an attachment pathology, a child rejecting a parent. So are they competent in attachment pathology? My guess is that no, they're not on either one of those. So they are practicing beyond the boundaries of their competence. Have they done anything to improve that, to change that, to apply the established knowledge on anything? So let's get accountability. Let's get review. So my question is, and this is my question, should Dr. Simon and Dr. Stahl lose their licenses for ongoing violations to multiple ethical standards of the APA, for their participation in the continuing misdiagnosis of child abuse pathology in the family courts, and for their continuing failure in their duty to protect obligations? Personally, I think they should. They're responsible for this model that resulted in thousands of children, the destruction of their lives, and they were left with abusive parents, and oftentimes they were recommended to be with the abusive parent because of the ignorance and incompetence in forensic psychologists, and this is their approach. And Dr. Simon and Dr. Stahl are not competent in the relevant domains of knowledge. Attachment and delusional thought disorders and child abuse and complex trauma, they've only worked in the family courts. And so if I look at their vitas and look at the situation, I think that's a reasonable question. Should they lose their licenses? If you believe a shared delusion, you become part of the shared delusion. You become part of the child abuse. When that, when that pathology is child abuse, they become participating child abusers. So my question would then be, of all their forensic custody evaluations, how often did they diagnose child abuse? That's always the diagnosis on the differential. So how many times did they diagnose child abuse? Failed in their duty to protect through all of their forensic evaluations because they don't know the knowledge, violations, ethical standards? I think that's license range. If you're participating in the child abuse, if you're disabling the mental health response so that we cannot protect children from child abuse, I think there's a reasonable argument to be made that they should lose their license, and that's fine with me. I think that's reasonable accountability for their negligent, what seemingly is negligent malpractice. But I'm just standard 1.04. I'm saying there's problems here that I'm seeing. By 11 to 9 margin, the commission said we need to eliminate custody evaluations because they are harmful to children, lack scientific or legal value, and that's what Dr. Simon and Stahl are doing. They're doing assessments or these custody evaluations that are harmful to children, that are dangerous, that lack scientific or legal value, and they are the ones that are proposing this. They're coming up with this awful, awful approach. So from me, just given this situation, I have ethical obligations. When psychologists believe there may have been an ethical violation by another psychologist, that's met. I believe there may have been violations 2.01, 2.04, 9.01, failure in duty to protect by Dr. Simon and Stahl. By another psychologist, they attempt to resolve the issue by bringing it to their attention. I'm bringing it to their attention. I went to the AFCC. I'm bringing it to their attention. This is pursuant, what I'm doing right now is pursuant to my obligations under 1.04. I'm not going to the licensing boards on Stahl and Simon and filing a complaint. I'm bringing it to public attention that there's a problem here that I'm seeing. If an informal resolution appears appropriate, I'm concerned about 2.01, 2.04 with Simon and Stahl. Now they can address this, they can answer this and say, no, I'm competent, and here's my boundaries. And I say, oh, okay, thanks, for reassuring me. But they have to, at this point, support it because all the evidence says they're not competent and they're in violation of multiple ethical standards. So I think they need to address their failed model and the consequences of that. Now, 1.05, if there's going to be, has substantially harmed, yes, there is, or likely to substantially harm, yes, there is. Blue Ribbon Commission, these are dangerous, harmful to children, and it's not appropriate for informal resolution. Okay, so maybe my next step is to write a letter to Simon and Saul and say, hey, I think you're in violation of these things. I've got one on my computer that I'm working up. Or is not resolved properly in that fashion. I went to the AFCC 5 years ago. I'm telling people I'm for, and it's not being resolved by the forensic psychologists. They simply don't care. Then psychologists, me, take further action appropriate to the situation. That's required of me. I have to take further action appropriate to the situation. So what am I doing? I'm getting on and telling the public that these are dangerous, that these are harmful to children, and that these forensic psychologists, not only Stahl and Simon, but all of them in all your cities and all your places are ignorant, incompetent, and unethical. Or that's the huge concern. And and then it says such action might be referral to, and they give me some examples. Well, the licensing board's not appropriate because they're controlled by the forensic psychologists. I went to the professional organization and told them, and I went to the APA and told them. So now, interestingly, on the APA one, this is Stahl and Simon. The APA petition to the APA, where 20,000 parents signed it, and we told the APA about the ethical violations in the family courts. What did the APA do about that? Now, all the psychologists in the APA have mandatory 1.04 and 1.05 obligations as well. So what did they do with it? Whoever they handed this petition to and said, here's a petition from parents, see what's going on with this. Whoever they gave that petition to is the person or persons who are disabling the mental health response to the pathology in the family courts. Because what needs to happen is the APA needs to get over here and solve this, because forensic psychology is going to collapse. They're going to be gone from the family courts. Clinical psychology won't come work in the family courts because it's too dangerous. So there will be no competent mental health services in the family courts. There never were, but now it'll be exposed. There will be no competent psychologists in the family courts. The APA needs to get over here and needs to look at the situation, needs to solve it. So whoever got this petition is the one disabling the mental health response to the pathology. So find out. Get a major media, get somebody to track it down, ask the APA, who did you give this to? And that will be the people that are disabling in the mental health system response. This is not a systems issue. This is people in the system. The forensic psychologists are financially exploiting these families. They are ignorant, unethical, incompetent, just the worst imaginable. They're just here taking their money, and they're covering up for all of that. And the moment this is all exposed, holy cow, I think all forensic psychologists should lose their license for unethical malpractice, failure in their duty to protect, and mostly a lot of participating in the child abuse because they believe a shared delusion is true, which makes them part of the pathology, part of the child abuse. All the individual therapists over in the family courts, I would look to see if they are participating in the child abuse because they misdiagnosed a shared delusion. That is, misdiagnosing a shared delusion is extraordinarily dangerous for the mental health person, because then we become part of the child abuse or part of the spousal abuse. And so we need to up our game in professional psychology considerably. And right now, though, we're just in a period of accountability. And so as this all gets exposed, and the failures of forensic psychology, Blue Ribbon Commission, these are not just nebulous ideas. These are individual people in locations in every city, and in within the APA, in upper echelons of that, within on the licensing boards. And the entire field of forensic psychology needs to be brought to a close. APA needs to get over here. We need to develop some standardized assessment and treatment protocols for the differential diagnosis of concern. Which parent is it? A shared delusion? Is it actual child abuse? We need to solve the pathology in the family courts and start protecting children from child abuse, and start protecting their parents from brutal emotional and psychological abuse by the pathological parent who's using the children as weapons. Yeah, with that, I'm going to end my talk on forensic custody evaluations. Again, somebody here going forward is going to need to explain to me why Stahl and Simon, why Robin Deutsch, why Matthew Sullivan, why all these forensic psychologists should not lose their license for negligently unethical and incompetent professional practice and failure in their duty to protect obligations. Explain that to me, because as far as I see, they are egregiously out of line, and their activity has resulted in the destruction of thousands and thousands of lives of children and of their parents, and those lives can't be recovered. Those children's lives who they've destroyed through the course of their 30, 40 years, they're destroyed. They're done. The parents lost that child. That's a done deal. And so there's no recovery for any of the damage that these ignorant, incompetent, unethical uh, people have wrought on these families. And they've been given plenty of opportunity to correct, to self-correct, to improve the quality. They just don't care. They're just immensely lazy. So I agree full-heartedly with the Blue Ribbon Commission that the practice of forensic custody evaluations needs to stop. However, then you won't have any professional services in the family courts, competent professional services. So good luck to people. The clinical psychologists, to make a point on that, they haven't worked in the family courts for 30, 40 years. So they don't know this pathology. They don't know the personality attachment, thought disorder, delusional, factitious attachment pathology in the family courts because they haven't worked with it. So they shouldn't come back. They'll be practicing beyond the boundaries of their competence. They haven't worked in the family courts. So we really need to get a handle on this. And that's the APA needs to come back, start holding some conferences. Those are the remedies that are discussed in the petition to the APA. So with that, I'm going to head off to my Sunday, and good luck, everybody. This is pretty much a nightmare in the family courts. So.